Welcome. It's a great pleasure to bring to you an annual event that the Environmental Law Institute has done that is looking at the environmental cases that are coming before the Supreme Court term this year, starting in October, and several of the leading ones that have come in the past. I'm John Cruden. I'm the president of the Environmental Law Institute. ELI, which is centered in Washington, D.C., is a research and educational institute. This is one of 60 programs that we'll be involved in. We encourage all of you to become a part of ELI. For law students, it's free, so you should do it. And if you do belong, then in fact you can participate without charge to these programs that we're putting on over the course of the year. There's something magical to all of us of this time right now, this waiting anticipation for the Supreme Court term to start. It is and represents the pinnacle of, in fact, American jurisprudence. And we all watch right now as the court makes decisions as to which of these cases that they're going to hear and then schedules them out. And we all watch and try to figure out where that will be, if in fact a case cert is granted, when that will get argued, when it will get decided, because of course these things affect not only the law, but they affect the entirety of our constitutional process. It is amazing to me that this particular year, which is an election year, as you all well know, that two of the most important parts of Obama administration were obviously health care and climate change. And both of those came before courts this year. Both of them had significant decisions, one of them in the Supreme Court. Some of that we'll be talking about today. But just the notion that these powerful policies, in fact, very often end up in court, and our court resolves that. The rest of the world looks in wonderment of our system that in fact brings closure, and there is a decision and people follow it. That is something we take for granted, and yet not anywhere else. We are blessed today. We really have two extraordinary panelists. For those of you with me at Harvard today, these panelists need no introduction at all. But for the many people that are listening on the phone, and there are people across the United States right now who are at their computer or at their phone listening and watching, because this is the gathering of the Environmental Law Institute. Particularly for those people, I want you to know who you're going to be hearing from. Our first speaker today is Professor Larry Tribe, pre-eminent scholar, professor and practitioner. His book, An American Constitutional Law, I believe is still the most cited constitutional law book in the nation, with over 35 Supreme Court arguments himself. He is, in fact, a great person to talk to us about the court. But I want to tell you two other things about Professor Tribe. One of them is, in fact, that right when I left Washington, D.C., the Environmental Law Institute is hosting officials of the Mexican Supreme Court, a little bit larger than our Supreme Court. They have 11 justices. We were there a month ago doing training in the court. They are here, and we were with them on Congress. Last year, Professor Tribe was the very first American ever to receive an honorary degree from the Mexican government. But I have another story that I've never told actually anyone, so it's fun to tell you all today. Before I came to the Environmental Law Institute for 2 decades, I was the senior career person at the Department of Justice's Environment and Natural Resources Division. One of the things that we did every quarter is sponsor pro bono service to low-income poverty clients that, if you know anything about Washington, D.C., are east of the Anacostia River. And so on a particular Saturday, I was assembling all the individuals who were going to spend the day, probably seeing as many as 50 poverty clients. And we were there about to start the briefing about how we were going to organize the day. There was one chair next to me, and out of the door comes to sit down next to me Larry Tribe. Because at that moment, he had been appointed by President Obama to be the very first counselor on access to justice at the Department of Justice. But he walked the walk He did with the things that we talk about. He did what he has been doing his entire life, which is service to others. Only that day he did it in a low-income community, poverty law clients, people who desperately needed our help. To his right is Professor Richard Lazarus, who himself has a dozen Supreme Court arguments. He's still written the book on environmental law that's on my shelf, which I consider the best, The Making of the Environmental Law. He is an incredible practitioner. In 2010, when Deepwater Horizon exploded and we had that massive undertaking which captured all of our attention there for almost 3 months, with oil gushing out into the Gulf of Mexico with extraordinary environmental problems, the nation, the president formed together the Deepwater Horizon Commission. Its executive director and author of the principal report was Professor Richard Lazarus. At that moment, I was Department of Justice. I was leading the litigation on Deepwater Horizon when that book came out. It was the finest legal publication I'd ever seen, and it also had the best pictures. On a personal note, not only have I been the benefit of Professor Lazarus' assistance and advice over the years, but not too long ago I was in Toronto. The American Bar Association had its annual convention there, and they gave their highest award for environmental work to Professor Lazarus, and he spoke movingly about the importance of environment in his life, and I can say firsthand the extraordinary contribution you have made, Professor Lazarus, to your profession and to the world of environment. So with that, I will turn it over, first of all, to Professor Tribe, then to Professor Lazarus. Both of them will finish their presentations, and then I will open it up to you for questions. So think about questions as you're listening. Larry?
Thanks, John. Thank you so much, John. I don't know how much you guys know about John Cruden, and I won't give you his whole CV, but he is an extraordinary public servant who has served under at least 6 attorneys general trying to keep the ship of state afloat, and justice served under a degree of partisan variation that boggles the imagination. It's a real honor and pleasure for me to be here. Before going into what I had planned to talk about, I do want to recall that Saturday afternoon in Anacostia in DC. Actually engaging in providing legal services of the sort that the president appointed me to try to encourage around the country was an extraordinary experience. I mean, I think I learned more and gained more from the people I met than I gave to them. But one particular experience I can't resist recounting to you. This guy needed some help in interpreting a will, and he wanted to know some details about the will, and his mother was involved and stuff, and I listened to him, and I said, just a minute, let me go and talk to somebody else. See, there were experts like John waiting in the wings to answer the questions of people who were simply volunteering for the day. And when I came back, I had something of an answer to him, and he said, by the way, are you really a lawyer? Which was a humbling experience. Reminded me that people who actually deal with clients and with human beings who desperately need our help and our services are what it's all about. Anyway, one reason it's a great honor to be here is that I think in 1969, when a late colleague and great friend of mine, Louis Jaffe, and I taught environmental law at Harvard Law School, it was, I think, the first course of that name in the country, and people kept asking us, what do you mean environmental law? We know what law is, we know what the environment is, but environmental law, that's a weird creature. Well, it's grown a vast amount since then, thanks mostly to people like Richard, and it's a great honor to be here to talk about a subject very close to my heart, the likely implications for environmental law of the Supreme Court's recent ruling in the Affordable Care Act. As some of you may know, I wasn't among those who expected the sky to fall when the court finally handed down its eagerly awaited decision in NFIB versus Sebelius. If anything, I was probably too sanguine about the likely outcome. Over a year before the decision came down, I predicted that the court would uphold every part of the ACA by a lopsided vote. As the country's mood shifted, not only on the wisdom of the law, but on its constitutionality, I started to waver a bit. I predicted a somewhat closer vote, one in which the Chief Justice would end up writing an opinion for the court, narrowly upholding the power of Congress to use tax incentives, even if the law described them as penalties rather than as taxes, to encourage everybody, however young and healthy, to purchase health insurance coverage as a suitably conservative way to avoid free riding on the healthcare system and to broaden the pool of those covered so that insurance companies would be able to absorb the added costs of complying with requirements that they cover everybody, regardless of pre-existing conditions, and without charging more to the old and the infirm than to the young and healthy. In an op-ed about a year before the argument, I wrote, "This law does not literally force anybody to do anything. It just increases the tax liability of those who refuse to buy insurance." And the Chief Justice, one of the most talented students I ever had, even though I don't always agree with him, gave signs of viewing it the same way during the oral argument this March, when he mused, and these were words that really struck me dramatically, buy insurance or else. Or else what? Or else nothing. Nothing, that is, except a modest increase in one's tax liability. An increase so modest that in most instances it would be cheaper for the individual to pay the added tax than to comply with the supposed mandate. Now, folks like Jeff Toobin, as he confesses in his recently published book on the White House and the Supreme Court, badly misread the court's questioning of the advocates during the oral argument. But I did remain convinced that the court would uphold the individual purchase mandate under the taxing power of Congress, because after all, the only thing that the law did was modestly increase the federal income tax liability of people who could afford to buy insurance and chose not to do so. It did not threaten such people with jail or even impose prohibitive tax penalties, but carefully calibrated its tax penalties so as to leave everyone with a meaningful option whether to buy insurance or experience a modest tax hike, a so-called shared responsibility payment for not doing so. And anybody who paid careful attention to the 3 days of oral argument in the Supreme Court, despite the obvious and sometimes sarcastic hostility to the act manifested by 4 members of the court, could tell that the Chief Justice was leaning toward viewing it as a constitutionally permissible tax. So on the eve of the decision, just as I had some weeks and months earlier, I went out on a limb to predict that the Chief Justice would write the court's opinion upholding the law on that basis. I didn't make any prediction about how Justice Kennedy would vote, or whether there would be 5 votes even to address the law's constitutionality under the Commerce Clause, because I didn't think that issue needed to be resolved once there were 5 votes to uphold it under the taxing power. But as it turned out, the Chief Justice disagreed. He concluded that the Commerce Clause issue had to be resolved in order to construe the measure as a tax, which he thought required reading it in a somewhat unnatural way. He ended up agreeing with the 4 most conservative justices on the issue of Congress's commerce power. He reasoned, as they did, that Congress could not use its authority to regulate interstate commerce as a means of compelling people to engage in such commerce by purchasing a commercial product that they chose not to purchase, even if that product, in this instance health insurance, constituted nothing more than a means of paying for another product, in this case health care, that virtually everyone is bound to consume at some time or other, often without advance warning. Now, lots of commentators, including colleagues like Charles Fried, President Reagan's Solicitor General and a good friend of mine, regarded that conclusion as, frankly, ridiculous. They insisted, and they continue to insist, that nothing in the Constitution's text or history supports a distinction between forcing people to purchase one product as a condition of consuming another and regulating commercial activity in any other way. Their famous response to the broccoli hypo was to say, so what if Congress might theoretically require everybody to buy broccoli? Why is that any worse from a federalism perspective than forbidding the purchase of broccoli? Both laws would be stupid, but the real safeguard against stupid federal laws is the political process, not the 10th Amendment. But as an intuitive matter, I do think that there was something to be said for the idea that drove 5 justices to draw the line where they did, despite the fact that none of the justices suggested that states, like Massachusetts, had to abide by any such line. Purely as a matter of liberty, it's clear that the police power of the states and of their subdivisions is broad enough to make people either buy things or to forbid them from buying things. But there are 5 justices who are determined to prevent the regulatory power of the federal government from becoming coextensive with the so-called police powers of the states. As the Chief Justice wrote, the government's theory in support of the individual purchase mandate would effectively establish that individuals may be regulated under the Commerce Clause whenever enough of them are not doing something that the federal government would have them do to solve almost any economic problem. As he pointed out, the failure of some people to have a healthy diet increases healthcare costs more than the failure of the uninsured to purchase insurance does. Under the government's theory, the Chief Justice reasoned, Congress could address the diet problem by ordering everybody to buy vegetables. And maybe so, opponents of the distinction between action and inaction say, but why is that any more offensive to federalism than addressing the diet problem by forbidding everybody to buy anything but vegetables? Now, my aim here is not to assess the constitutional wisdom of the action-inaction dichotomy. Rather, my aim is to say a few words about the implications for environmental law of the fact that 5 justices embraced that dichotomy as a limiting principle in defining Congress's power under the Commerce Clause, while another 5 justices rejected the same dichotomy as a limiting principle in defining Congress's power to tax, with a Venn diagram at whose intersection one could find only Chief Justice Roberts. Now, at first glance, it might seem counterintuitive to imagine that a court, or in this case, a Chief Justice, reluctant to uphold Congress's power to command somebody to engage in commerce under the Commerce Clause, would be willing to uphold the very same power through the Taxation Clause. But the Chief Justice developed a theory that explained the difference. Although increasing the income tax liability of people deliberately going without insurance would, of course, encourage everybody to purchase such insurance, it wouldn't truly compel that purchase, because it would neither trigger a penalty greater than the cost of buying the insurance, nor make outlaws of those who fail to buy it, but pay their increased tax instead. That is, it wouldn't subject non-purchasers to the full force of Congress's power to criminalize activity and to imprison violators. Congress's authority under the taxing power is limited to requiring someone to pay money into the federal treasury, no more, the Chief Justice wrote, by thereby insisting that the power to tax not become a power to destroy. The Chief Justice avoided the most dramatic inconsistency between his 2 conclusions. More to the point of today's session, the Chief Justice could, without contradiction, illustrate the resulting set of constitutional principles by giving an environmental law example. Congress, he noted, could certainly enact a statute, and I am quoting him, Congress could certainly enact a statute providing that every taxpayer who owns a house without energy-efficient windows must pay $50 to the IRS. calculating the amount due on the basis of factors like the taxable income and joint filing status of the taxpayer, and providing that it be paid along with the taxpayer's income tax returns. It wouldn't matter, he said, what the required penalty was called, a tax or a penalty or anything else. No one would doubt, again quoting the Chief Justice, that this law imposed a tax and was within Congress's power to tax. And because the federal taxing power is not limited to the things that Congress is able to reach under any of its enumerated source of regulatory power, that's a far-reaching conclusion. To the degree that someone's conduct causes environmental externalities, even if they are purely intrastate and non-commercial, Congress now clearly has the power to require the source of that conduct, be it carbon emissions or anything else, to internalize whatever Congress deems its costs to be, so long as the resulting tax is not so steep as to effectively prohibit the conduct and criminalize it. The limit on that invocation of the federal taxing power is the idea of coercion. Congress may use its power of taxation, a power conspicuously not limited by the categories of regulatory authority otherwise enumerated in Article 1, to nudge people and institutions into behavior that Congress deems environmentally sound or otherwise in the general welfare, but not to bludgeon them into such behavior. Under provisions like the Commerce Clause, the Chief Justice said, the federal government can bring its full weight to bear. Congress may simply command individuals to do as it directs, subjecting anyone who disobeys to criminal sanctions, including not only fines and imprisonment, but all the consequences of being branded a criminal, deprivation of otherwise protected civil rights, such as the right to bear arms, an interesting thing for the Chief Justice to include at the very head of his list, or to vote in elections, to lose employment opportunities, social stigma, severe disabilities, and other controversies such as custody or immigration disputes. Now, there is a striking parallel between what a bare majority of the justices ended up holding with respect to Congress's power over individuals and what 7 members of the court ended up holding with respect to Congress's power over states and municipalities. They, too, could be nudged and cajoled and incentivized with carrots, but not bludgeoned with sticks. With that idea in view, 7 justices concluded that Congress's spending power did not permit it to threaten cutting off all the federal Medicaid funding for any state's pre-existing Medicaid programs, which is over 1/5 of the average state's total budget, unless the state agreed to revise those programs by 2014 to conform to the Affordable Care Act's dramatically expanded categories of eligible individuals and services. Viewing the state's existing Medicaid funds almost as though they belonged to the states as a matter of right, the Chief Justice, surprisingly joined by Justices Breyer and Kagan, agreed with Justices Scalia, Kennedy, Thomas, and Alito that the offer extended by the Affordable Care Act, when backed up by this threat, was one that the states had no realistic capacity to refuse. It was, according to the Chief Justice, much more than relatively mild encouragement, but was instead a gun to the head. Now, maybe because the court had never found a congressionally imposed condition on federal funding impermissibly coercive since the mid-1930s, and because not a single lower court had found the Affordable Care Act to entail forbidden coercion, this was a holding that surprised virtually everybody who watched the litigation, including me, I have to confess. Now, I don't know of any special leaks to this effect, but I suspect that one reason Justices Breyer and Kagan joined the Chief on this branch of the holding was to cement the Chief Justice's willingness to strike down only the Affordable Care Act's threat to withdraw existing Medicaid funds from states that declined to comply with the new broadened expansion, and his willingness not to follow his 4 more conservative colleagues in their conclusion that once the threat was struck down, the whole Medicaid provision, and with it the rest of the Affordable Care Act, had to fall as well. So the upshot was that the court limited the financial pressure the Secretary of Health and Human Services could apply to induce states to accept the terms of the Medicaid expansion, but left in place the fiscally tempting offer that the Affordable Care Act made to every state as an inducement for it to accept those terms. Now, the court's Medicaid holding, the first of its kind in 3/4 of a century, is bound to unleash an avalanche of constitutional attacks on any number of environmental and other laws. For example, provisions of the Clean Air Act condition a substantial amount of federal highway funding to the states on whether the states meet specified air quality standards. And other provisions make the issuance of permits for constructing new facilities conditional upon state achievement of those standards. Any federal statutes or regulations that use that kind of leverage to induce state behavior or achievement of designated goals will be natural targets for challenge after NFIB versus Sebelius. To the degree that federal spending conditions can be plausibly described as just specifying how federal funds will be spent, those conditions are, I think, completely safe from such challenge. But to the degree that they entail the use of leverage, making federal largesse, either in the form of dollars or in the form of federal permits, depend on state compliance with independent federal requirements, they might well be vulnerable. On the other hand, when that kind of federal leverage gives states an escape hatch in the form of a federal backup plan under which states that refuse to succumb to federal blandishments or pressures end up having to step aside while federal authorities directly impose their own standards, I think nothing about what the court did poses constitutional difficulty. Now, I'm not going to take the time here to, I've already taken too much, I think, to apply those principles to specific federal provisions, but I would point you to two articles, one by Professor Sam Bagenstos of Michigan Law School, called The Anti-Leveraging Principle and the Spending Clause After NFIB, and the other by one of our own Harvard Law students, David Bach, called Federalism in the Air: Is the Clean Air Act's My Way or No Highway provision constitutional after NFIB versus Sebelius? It's going to be published soon. I think both of them, about which Richard might have some observations, are excellent expositions of how far NFIB versus Sebelius might go to undercut federal spending conditions in the environmental field. Now, some observers have suggested that by upholding the individual purchase mandate, the Chief Justice conspired to trick liberals and environmental progressives into thinking that they had won, while in fact imposing newfound and exacting limits on the Commerce Clause. I don't think so. The action-inaction distinction endorsed by the 5 justices who voted to hold that Congress could not impose the purchase mandate through the Commerce Clause, however dubious some people might find that distinction, won't do very much to tie Congress's hands going forward. It is true that congressional action mandating economic activity is not unprecedented. For example, Congress in 1792, with nearly 12 framers on board and with George Washington's signature, enacted a law requiring all able-bodied males to purchase firearms. But that was a provision akin to military conscription, and it rested, as the Chief Justice pointed out, on Congress's explicit power for arming the militia. In matters of economy or ecology, Congress very rarely mandates behavior on an individual level to accomplish its regulatory goals, not because the Constitution truly precludes it, but because our culture profoundly frowns upon it. The federal code, you will notice, is not littered with other individual mandates, environmental or otherwise, for litigants to pick apart. And after the bruising battle over health care reform and the largely successful effort of the law's opponents to persuade lots of Americans that Congress should refrain from similar regulatory approaches, outright mandates directing individuals to take specific actions beyond paying taxes, serving on juries, and cooperating in the defense of the country and of their communities has lost much of its prospective legitimacy in the realm of popular constitutional discourse. So Congress would not have been likely to follow healthcare with similarly structured programs, regardless of how the Supreme Court resolved the Commerce Clause issue in the ACA case. And it is important to note that the 5 justices who found the individual purchase mandate to exceed Congress's commerce power reiterated, rather than repudiating, the Commerce Clause framework laid out in 1995 in the Lopez decision. Congress may regulate and protect people or things in interstate commerce, or the channels and instrumentalities of interstate commerce, even from threats arising from purely intrastate activities. And Congress may regulate intrastate activities that substantially affect interstate commerce, including activities that have such an effect only when viewed in the aggregate, providing the activities thereby aggregated are economic in character. Nothing, I repeat, nothing about the doctrinal structure set out in Lopez has been changed by the ACA decision. Now, it is true that the mood exhibited by 5 of the court's 9 justices represented a shot across the bow. And it's a stronger shot than the court lobbed either in 1995, when the Lopez case struck down the federal ban on possessing guns near schools, or in 2000, when the Morrison case struck down the federal creation of a cause of action for victims of gender-based violence. I say it's stronger because the laws struck down in those 2 cases honestly did not represent hugely significant attempts to tackle major national economic problems. The willingness of 5 justices to treat the Commerce Clause and the Necessary and Proper Clause as insufficient to sustain this signature effort to address a multi-trillion-dollar interstate economic problem sent a far more ominous signal in Congress's direction. But my own sense is that Congress's internal paralysis, both partisan and structural, is a far graver threat to endangered species, to the nation's resources, and to global ecosystems than anything to be found in the tea leaves of the Supreme Court's ACA ruling. Now, some people I know have worried about the implications of the Chief Justice's dissent from the denial of rehearing en banc in the famous D.C. Circuit case involving the hapless little Arroyo southwestern toad that was imperiled by the real estate development in San Diego. In that 2003 case, Rancho Viejo versus Norton, the D.C. Circuit upheld the federal government's regulation of that development through its ban on takings of protected species under the Endangered Species Act. Well, I've now reread both that dissent and the colloquies in September 2005 during the Roberts confirmation hearings, and I just see nothing that would lead me to worry that Chief Justice Roberts is likely to escalate his determination to limit federal power under the Commerce Clause into a significant new source of limits on federal power to regulate economic activities with significant aggregate effects on the interstate economy, or to narrow the definition of what counts as economic activities. For example, Senator Schumer pressed the future Chief Justice with a hypothetical question about whether Congress could pass a law under the Commerce Clause banning even non-commercial cloning. Roberts seemed entirely comfortable responding with the usual disclaimers about not meaning to give binding opinions, that Congress could of course do that. Now, it's anybody's guess how the chief would rule in an actual case, but I don't see anything in his background or in his approach to the ACA that suggests a programmatic desire to cut back on congressional regulatory power in the interest of restoring a pre-1937 constitutional dispensation on the nature of the federal-state boundary over social and economic life. I think it's significant in that regard that nothing in the Chief Justice's opinion in the Sebelius case dwelled on the supposedly local character of matters regarding healthcare and medical services. That suggests to me that he would not be so likely to treat regulation of economic activities affecting local wetlands or other non-navigable tributaries of traditional navigable waters as categorically beyond the reach of federal authority. Having drawn a bright line at the distinction between activity and inactivity, I doubt that the Chief Justice would join the 4 who wrote separately to strike down the whole ACA to add still further bright lines to constrain federal regulatory power. Of course, all of this is conjecture on my part, so I should close with Yogi Berra's wise reminder: predicting is hard, especially the future. Thank you very much. Thanks.
Well, I'm absolutely delighted. Could not be more pleased to be joined here by Professor Tribe. He's well known as one of the nation's foremost constitutional experts, Supreme Court experts. But in my world, it's also known, as he mentioned, he was Harvard Law School's first environmental law professor. He taught it in '69, and he also authored one of the nation's first environmental law case books in 1971 with Louis Jaffe. All right, here's my charge. Professor Tribe was talking about the Affordable Care Act case, its potential implication for environmental law. My focus is more classic environmental law cases, the ones decided last term and the ones before the court this upcoming term. One threshold warning: my cases involve a lot of water, so be prepared for lots of water. All right, last term, one big environmental law case, that was Sackett versus EPA. Immediately following the oral argument in the Affordable Care Act case, as Professor Tribe mentioned, Jeffrey Toobin very famously said right outside on the steps that this case was a train wreck. The oral argument was a disaster and the government was destined to lose. Toobin's mistake was not looking to a case decided just a week before that one. That was Sackett, and that was a true train wreck. Now, let me tell you what made Sackett a train wreck. The facts before the court, at least the facts before the court as the justices understood them. In that case, we had a married couple who owned 2/3 of an acre of a residential lot in Idaho, and they wanted to build a home on it. And so they put on the lot some dirt and some rocks in order to build a home. They then received an administrative compliance order, a written order from EPA, which said what they thought was land was in fact the navigable water of the United States, and they had violated the Clean Water Act. They needed to immediately remove the fill, and they now are subject to a $70,000 a day per day violation. One for violating the statute, that's half of it, and the other now for violating the order they just received, the other half. The Sackett said, we'd like a hearing, administrative hearing to, see, we don't think this is the navigable water of the United States. The EPA said no, no hearing. They then said, all right, we're going to bring a suit to get a court because we don't think this is the navigable water of the United States. The EPA said no, you don't entitled to go to court to challenge this at all, and the Ninth Circuit agreed. Now those are bad facts. And the court didn't hide its actual outrage at the government at the oral argument of the case. Not surprisingly, an unanimous opinion by the court, written by Justice Scalia, the court had little trouble finding the Sacketts were entitled to judicial review. The court first held the administrative compliance order they had received was clearly final agency action within the meaning of the Administrative Procedure Act. It amounted to a consummation of a final agency decision-making process. It had immediate and significant legal consequences. After all, the order itself said, if you violate this order, you're subject to $37,500 per day of violation. The court then rejected the government's argument. The Clean Water Act itself precluded judicial review, overcoming the APA. They said there's nothing in the language of the statute which actually says that, and we don't find the argument you have that the structure of the statute evidences that congressional intent even a close question. All right, so what are the lessons of the case, and what are its practical and presential significance? First, the lesson: it's often said that bad facts make bad law, but that's not actually what happened here. Actually, there's some reason to think the facts really weren't as bad as they seemed in terms of the Sackett's innocence. I don't really think this is a bad facts case. I think this is a good old-fashioned bad legal argument case. And I don't think this is necessarily a case where bad law was made. I actually think this is probably good law that was made. You can't send this kind of order with the wording this order had and then claim there's no judicial review. The Deputy Solicitor General in this case deserves some combat pay for making the oral argument for the justices. This was not an easy argument. Environmental protection is good. Section 404 wetlands protection is absolutely essential, but it's no excuse for running roughshod over basic fairness. Environmental protection shouldn't depart from that basic notion. Now, the practical significance of the case, though, I think is limited. And that's because the government can achieve just about everything it wanted here without having an administrative compliance order. It could take this same letter, scratch out the top administrative compliance order, not order them to do anything, tell them, we think you violated the Clean Water Act. Under the Water Act, you're subject to $37,500 per day of penalty if you don't undo the violation, and leave it at that. The practical effect would have been, in terms of leverage over the sackets, exactly the same, especially since the government never actually went for double penalties of $75,000 anyway. They would just reduce the obvious finality of it, and they would avoid the overkill they had done, completely unnecessary. The precedential significance of the case is also limited. The real issue in this case was a due process issue lurking in the case. In fact, the petitioner in this case had barely pressed the question whether the Clean Water Act itself provided for judicial review or negated the APA's availability of judicial review. They instead argued that there was no judicial review under the statute, and that would mean there would be a due process violation. The court found there was judicial review under the APA and never reached the due process issue. If the court had reached the due process issue, that would have been a significant ruling for many defendants in many cases, including in the Superfund law, where this issue has been lurking for quite a long time. All right, two other quick cases from last term I want to mention. I'll take questions later, but just a few words. The first is PPL Montana v. Montana. This concerned a dispute over the ownership of the beds of navigable waters in Montana. Now, that might seem to be a pretty rarefied issue for folks, but in my world, that's a big deal. It's such a big deal that that's why when states get admitted to the Union, they actually get ownership of the beds of navigable waters. It's one of the essential attributes of sovereignty. It's one of the big things they get when they are admitted to the Union. Now, the parties in this case disputed on how you decide whether or not a particular water body is navigable at the time of statehood. The state of Montana said you looked at the river as a whole, and whether the whole river is navigable. And if little parts of it aren't, the whole river still is. The other side said you got to go segment by segment. You look at each segment, decide whether each segment is navigable, which allows for more precise definition. And the answer is, in a unanimous opinion by Justice Kennedy, you go segment by segment. So the state of Montana lost. And the court also said, if you look at a particular segment and you actually would have to go do portage by land over that segment and it would take you a day, that's no longer navigable water. So that eliminates it. The second case is Southern Union Company versus United States. This is a Resource Conservation Recovery Act case involving a violation of that statute for storing a hazardous substance without a permit. And the issue in this case was whether it had violated the Sixth Amendment to have the criminal fine in that case determined by a judge and not by a jury, when the statute based the amount of the fine on the numbers of days of violation, and the jury had never calculated the number of days of the violation. The court ruled there had in fact been a Sixth Amendment violation in that case, saying that Apprendi applied to criminal fines, and the jury had to calculate the number of days. This is significant in many areas, but certainly in environmental law, almost all the environmental law statutes have penalties based upon days of violation. All right, October term 2012. There have been 3 cases already granted. There's a flooding takings case and 2 stormwater discharge Clean Water Act cases, realizing my promise of more and more water. All right, first, the flooding case. This is the Arkansas Fish and Game Commission versus U.S. case. This is a case where the U.S. Army Corps of Engineers operates a dam in Missouri. Now, as part of that operation of the dam, they decide how much water goes downstream. And they have a manual which says generally how much water is going to be allowed downstream in controlling floods. Now, they can do deviations from that if they want on occasion. From 1993 to 2000, that's what the Army Corps of Engineers did. They authorized certain deviations to address the needs of certain riparian landowners. The problem is when you do some deviations, you're sending water from one place to another. And some downstream folks did not appreciate the amount of water they received downstream because that flooded their property, including the Arkansas Wildlife Management Area run by the Arkansas River Wild and Rivers Commission. And they suffered $5.8 million of damage to hardwood forests that were damaged from the flooding there. So what's the legal issue before the court? The legal issue before the court is, when does flooding constitute a Fifth Amendment taking requiring the payment of just compensation by the government? And this case involves the battle of the per se rules. And I have to give a slight disclosure here. My brother works for the Department of Justice, and he's co-counsel for the United States in the case. The U.S. argues that there's a per se no-taking rule, that temporary floodings do not constitute takings. Permanent floodings do, temporary do not. They say in other contexts you can have a temporary taking, but flooding is different. They say there's settled law on this, decades of Supreme Court precedent saying that floodings have to be permanent in order to be a taking. And they said the burden imposed by flooding is different. Flooding goes naturally away. And riparian landowners understand their land is subject to flooding, so their expectations are different. The amicus on the other side, supporting Arkansas, however, had the opposite per se rule. They say temporary floodings are always takings, that they're just takings for a smaller period of time. If you flood someone's property for a discrete period of time, you got to pay them for the period of time that you took their property, clean and simple. Happily, both the United States and Arkansas have backup arguments in this case. Say, all right, if you don't believe it's a no per se taking, or you don't believe it's a per se no taking, you should apply a balancing test that does an ad hoc factual analysis. They agree on that, then they both do an ad hoc balancing test and come to different results. One says it's a taking, one says it's not a taking. The U.S. stresses a few things. One, again, riparian landowners have diminished expectations because they know their property is being flooded. Second, the Army Corps of Engineers here is actually trying to do a public service. They're trying to balance the benefits and burdens to all these landowners up and down the river. And second, everyone is advantaged by their doing so. There are benefits overall to these flood control things. Sometimes you win, sometimes you lose, but over the long haul, everyone is a winner. The likely outcome of the case, this is actually a big case, not just for this one, but the Army Corps of Engineers doing flood control management around the country. The government is clearly worried about this case. They're worried so much that in August, just a few weeks ago, they offered the other side $13 million to settle the case. The other side rejected it, even though the original damage was $5.8 million. They wouldn't have offered that unless they were worried about what the court might do here. The other side wouldn't have rejected it unless they were pretty optimistic what they thought the court might do in this case. This is a conservative court. There are 5 justices who are very concerned about private property rights, and they believe the Fifth Amendment Just Compensation Clause be used to protect them. I think the court will probably likely reject the long-standing rule which has said that temporary flooding is not a taking. I actually don't think, though, they're likely to embrace the other side and say that temporary flooding is always a taking. This just tends not to be a court in favor of per se rules. It's a court which tends to favor more in this area balancing tests. Justice Kennedy will likely be the swing vote in this case. The government has one disadvantage: Justice Kagan is out. She's recused from the case, probably because of involvement in the case when she was Solicitor General. This case also has the notoriety for having one of the most interesting clients for an amicus brief filed, and that is the state of Arkansas was supported by an amicus brief filed on behalf of the Rough Grouse Society, which was a first for me. All right, our next are 2 Clean Water Act stormwater cases granted in June to be argued both in December, one December 3rd and one December 4th. There are actually 3 cases, but 2 of the 3 are consolidated cases with the same issue, so I'm just going to refer to them as 2. The first is Decker versus Northwest Environmental Defense Center. The second is LA County Flood District versus Natural Resource Defense Council. It's no happenstance both these cases involve stormwater discharges. Stormwater discharges are a huge issue in environmental law. They are the major reason why the nation is not achieving its nation's water quality standards. And it's been very hard to get national rules in place for stormwater discharges. Hard technically to control the runoff from stormwater discharges, and very hard politically because it tends to control a lot of sources which are politically powerful, including the agricultural industry, the silviculture industry, and municipalities. Environmentalists also have a lot of reason to be concerned in both these cases. In both these cases, they won below. In both these cases, the decision was from the Ninth Circuit. In both cases, the court, before granting review, asked the Solicitor General whether they should take the case. In both cases, the Solicitor General said, no, don't take the case. The issues are not important. And the court took it anyway. Now, typically when that happens, that means there are at least 4 justices out there favoring review because they think this case requires reversal. All right, let's look at the Decker case first. This case concerns contaminated storm runoff from logging activities that flow into a series of ditches and culverts that then flow into navigable waters of the United States. The issue is whether that flow from the ditches and culverts constitutes a point source subject to Clean Water Act permitting requirements. Now, the environmentalists have a pretty good argument on the other side based on the plain meaning of the statute, because the statute actually defines point source to include, and I quote, ditches and culverts. And there's nothing in the statute which provides an exemption on the face of the statute for logging roads at all. Now, industry and EPA, though, and EPA has joined industry in this case, and opposing environmentalists, now that we're on the merits. They can point to two EPA regulations, one promulgated in 1976 and one in 1990, which they can say actually take the position the statute should not apply to logging roads. Then they can further argue that you can't challenge the validity of those regulations in a citizen suit under Section 509 B2 of the statute. If you want to challenge the validity of regulation, you had to have done that directly, and you never did that. So you actually have to assume the validity of the regulations in this citizen suit. Now, in the court, this procedural posture of the case poses a major threshold problem for the environmental plaintiffs. They have a strong argument on the merits, a strong plain meaning argument based upon the statutory language, a strong Chevron 1 argument. And to the extent EPA's regulation of the contrary, they'd be entitled to no deference under Chevron. The problem is that they can't do that. They can't challenge the regulation. The other side's absolutely right on that. 509B2 says you can't challenge the validity of regulations in a citizen suit. That provision is mostly designed really for the defendants not to be able to do it, but there's nothing in the language to say that plaintiffs can do it too. And so they have to worry about challenging the regulatory interpretation, and that's much harder. EPA is on much stronger ground in arguing what they think the regulations mean. They wrote them. They wrote them that way. And the regulations can be much more strongly read the way EPA is claiming. The Ninth Circuit managed to find a different interpretation of the regulations, but that's going to be hard to defend. If this case were just up and down on the statute, the environmentalists would have a very strong case. It's going to be harder for them. It's not out of the question. It's just going to be harder for them when it comes to interpreting the regulations. The irony of this case, though, if the environmentalists win here, this will be a big win for controlling point source runoff. And this is something EPA has long and too long avoided. But the downside is, if they actually are allowed to do what they want to do in terms of the regulations, that's going to help a lot of defendants in future citizen suits in challenging the regulatory interpretation when they're trying to defend these cases in the future. All right, next case is the LA County Flood District v. NRDC case. For this one, too, I have a threshold caveat. It's not my brother, it's me. I'm co-counsel in this case to the respondent, Natural Resource Defense Council. On this one, I will tell you I cannot offer a candid, objective assessment of the case. There's a thing called attorney-client privilege, which gets in the way. So with that caveat, let me tell you what this case is about. This is a case involving LA. If you picture Los Angeles, you have stormwater throughout LA County picking up contaminants, flowing into rivers and into the Pacific Ocean. There are thousands, literally thousands of outfalls and pipes throughout the city. Most are owned and operated by LA County, but not all of them by LA County. But under the Clean Water Act, all those sources, all those thousands of sources are all subject to one Clean Water Act permit. And that permit says that discharges can't violate the water quality standards in the rivers and in the ocean. And the permit requires monitoring in the river to determine whether or not those water quality standards are being violated. Now, NRDC looked at those monitoring results and they said, they're water quality violations. We can see them, and no one denies them. So they brought a lawsuit against LA County for violation of the permit. LA County says, all right, we agree. There's clearly a violation of the permit. But where's the proof that we did it? There are thousands and thousands of outfalls. Many of those thousands are ours, but they're not all ours. You've got to show that ours are the ones that caused that water quality violation. NRDC says, no, we don't have to. We don't have to fingerprint it. It's enough to show the permit is violation and you contributed as part of being subject to that permit. Now this is where the case gets tricky. The Ninth Circuit rejected NRDC's legal theory. They said that showing a water quality violation is not enough to show that LA County is responsible. You have to show more. And then they ruled for NRDC that they had showed more, but without adopting NRDC's theory. And let's just say the precise reading of the Ninth Circuit is a little bit hard to discern. It's not exactly clear where they found the evidence. Now, the LA County and NRDC read the Ninth Circuit very differently, but both said the Ninth Circuit screwed up to some respect. LA County says that they found LA liable only by saying that the parts of the LA River which had concrete channels, which you probably have seen, which LA put in, by treating that as a point source and not as a navigable water of the United States. And they said that's clearly wrong under EPA regs and Supreme Court precedent. So you should reverse. NRDC says if the Ninth Circuit had said that, we would agree they were completely wrong, contrary to Supreme Court precedent and a regulation. We don't think they said that. We think they just made a factual error about exactly where the monitoring station was. They thought it was over here when it's really over there. And that factual error shouldn't change the result. The judgment should still be intact. Now, normally, in this posture, the court does one of two things. They deny cert. They say, all right, there's no big issue here. They do what the Solicitor General told them, no big issue, no big dispute. Everyone agrees on the big issue that's the same result. This is just a factual dispute going on. Deny cert. We're not here as a court to correct all errors. Or they GVR the case. Grant, vacate, remand, send it back to the Ninth Circuit to explain what it is they were thinking and what they did. Instead, what the court did was it granted review on the merits. That makes this case somewhat of a mess. Because on the legal issue the court granted, there's unlikely to be any difference of view on the two parties, petitioner respondents or the United States. Everyone seems to agree on the legal issue the court granted review on. So the whole case is going to focus on other matters. And its oral argument in that case is going to be quite a challenge for both parties as a result, as the court has to grapple with exactly what it's granted review. And whoever is the clerk who wrote the cert pool memo, which got this case granted, luckily for that clerk, is long gone. They would have left in June. So the justices are, I think, going to be a bit unhappy. Other couple of things just to mention. The court has a few other cases on its that it could take. It's got a pending cert petition, a case called Wyoming versus Department of Agriculture, number 11-1378. This is a case involving Department of Agriculture's roadless rules, which are being challenged for violating the Wilderness Act, and also being challenged by Wyoming for violating NEPA, for Department of Agriculture not doing sufficient analysis of the environmental impacts of the roadless rules. This has been an issue batted back and forth between various administrations for decades. The Obama administration promulgated a very ambitious rule, carving out a whole area of national forests from all kinds of development activities and industry, and some of the western states are upset about it. The court could have granted cert on that case at 9:30 this morning. They didn't. That's a strong suggestion the court's going to deny review, but we'll have to wait a little bit to find out. Then there are a couple cases, recently cases from the DC Circuit decided this past summer, where it's quite possible cert petitions will be filed. There's the Coalition for Responsible Regulation case that John Cruden alluded to before, which is the case involving EPA's determination that greenhouse gas emissions of motor vehicles endanger public health and welfare, and several rules they promulgated associated with that to regulate for motor vehicles and stationary sources. EPA won a very big case in the DC Circuit in June, and it's quite likely that the other side may petition for Supreme Court review. And finally, a case decided just a few weeks ago in the DC Circuit, the EME Homer Agency, the EPA case. This involved a case where EPA lost a major ruling in front of the DC Circuit, where they lost their most recent effort to promulgate a rule addressing interstate pollution transport under the Clean Air Act. This is something that EPA has struggled with for quite a long time. They won a big case a decade ago. They've lost several efforts since then to promulgate these rules. This was a stunning loss for EPA and a major loss for EPA. My guess is they're certainly going to seek rehearing en banc, I would guess, and they may well seek Supreme Court review. And that's it. We'll leave it for Q&A. Thank you.
So I want to turn it over to the audience if you have questions, but while you're thinking about it, I have one for Professor Tribe. In the series Harry Potter, there is the one person, Lord Voldemort, that is the person you never talk about. When I look at the dissent in NFIB, it's like John Roberts is Lord Voldemort. Why is that? I've never read a dissent that really doesn't talk about the person writing the majority.
Well, it is striking. I mean, there's not a word about Lord Voldemort in the dissent or about his alter ego, John Roberts. The Scalia, Thomas, Alito, Kennedy opinion proceeds as though Roberts didn't exist. Now, some speculate that that's because they were sort of pissed that Roberts departed the fold somewhere in the process. I'm not so sure of that because I thought from the beginning that Roberts was leaning in the direction of upholding the act, but I'm sure he kept his options open. They were obviously, if not disgruntled, they weren't entirely gruntled. And they clearly wrote an opinion that did not want to refer to him. That also deprived him of a majority on a number of issues. At one point, he had to say that his opinion saying that there was no constitutional authority under the Commerce Clause and under the Necessary and Proper Clause was in accord, he used the word accord, with that of the joint dissent. So there are all kinds of mysteries, but in the end, I don't know that they matter a lot. I mean, these books, I like Jeff Toobin, he's a friend, he's a former student, but all of these books that get so breathless about who is upset with whom for a little while don't give you the slightest bit of insight into what the court's decisions mean for the nation's future. So that when Jan Crawford sort of comes out with her leak that Scalia isn't talking to Roberts and then Scalia denies it, I suppose gossip is fun. I like gossip as much as the next guy, but if you really want to know where the country is going, where the court is going, in what way our future will be affected, I think you treat that the way you treat the shores of New Jersey. It just doesn't exactly tell you very much.
And again, I'll open to questions, but I want to ask Professor Lazarus, and then I know that you're involved in the LA case, but at first blush, I think those of us who are following the case thought this was kind of the son or daughter of the Supreme Court's Miccosukee decision. And either, I don't know, it's either at oral argument or in the opinion itself, where they have this famous line that if you take a ladle of water out of a body of water and you put it back, then that's not the addition of a pollutant. It's the same water body. And that was, by the way, as I recall, the only great thought that came out of that entire opinion. But is Miccosukee even relevant to the LA case?
Well, that's exactly what the court said, actually in the opinion in Miccosukee. And the reason why that case is at least implicated in the LA County case is if you read the Ninth Circuit opinion, it's saying that the only reason that LA County is responsible is because of those channelized concrete lines, a part of the LA River. That would mean they're responsible for pollutants that were on one side of the concrete and then on the other side of the concrete. And that's the sole basis of their liability. The pollutants were there in the LA River, then they went through the part of the river which LA County had the concrete on the side, and they came on the other side, and that would be basically the practical equivalence of a ladle. It's true on both sides. And that's one where LA County says that if that's the case, this is with Miccosukee. That's where the United States filed an amicus brief and said, if that's the case, that means this is with Miccosukee. And that's where actually NRDC has said, if that's the case, that means this is with Miccosukee. So everyone actually agrees with that. And then people are trying to, then NRDC will defend the judgment really on alternative grounds than that. One interesting aside about that part of Miccosukee, though, which I find fascinating, is that in that opinion, the Supreme Court said that, and they actually said that the respondent tribe, the Miccosukee tribe, had conceded that point in the case, that if you actually moved pollutants within the same water body, that could never be an addition. That was not true. It was just a completely incorrect concession. If you actually look through the argument of the case, they asked the Miccosukee tribe's lawyer that 2 different times. Both times he said, that is not true, that is not our position, it would still be an addition to pollutants, even if it was the same water body. They filed a petition for rehearing after it saying, quoting out from the argument, that is not true, we did not say that, doesn't make any difference. Once the Supreme Court says you said it, it turns out you said it.
Please, questions. Please.
So my question is for Professor Lazarus, and that is, we heard about water, 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 water. How do you view the cases past and pending as potentially affecting the AIR Acts and global climate change and the efforts of EPA to combat climate change?
Yeah, I'm going to repeat the question because we have, again, a number of individuals listening on the phone or breathlessly anticipating the answer in their computer. And the question really is, can you put these cases into context of the other cases the Supreme Court has done, please?
Yeah, I mean, Actually, I would share exactly what Professor Tribe said. I don't read any of these cases as being the major impediment and hurdle to enacting the kind of laws we need for global climate change. Boy, well, it seems to be working. It sounds, all right?
We hear it.
All right, I'll try this, see if that works, all right? Okay. I agree exactly with what Professor Tribe said, what Larry said, and that is that nothing the Supreme Court is doing in this area right now is having a major impact in terms of our ability to really address the climate change issue. We have a major lawmaking, part of the nation's lawmaking structure, which is completely broken right now over in Congress. And actually the courts are not the significant impediment here in that area.
Please, to my right.
I have a question for Professor Tribe on the coercion issue. I was wondering if the Supreme Court provided sort of a more detailed test for what would count as a gun to the head of states, and whether you think that sort of, lawmakers and the government will be able to sort of predict how the court will rule in the future on that, or whether it's sort of still an open-ended question.
Would you repeat the
Yeah, the question is whether the court gave any predictable guidance for lawmakers as to what would constitute coercion when it comes to the use of the spending power. And there's a very simple answer: no. I mean, the opinion is completely opaque as to how far you have to go before it's coercion. I mean, in the course that I taught at the college that you were in last semester, I talked about the kind of analytical incoherence of the coercion concept. It's sort of it's a normative concept in descriptive garb. The question of whether something is a gun to your head really can't be resolved by asking just how much they're twisting your arm. If it's your arm, they're not allowed to twist it. The question is if they're saying, I won't give you something unless you go along, and if it's not something you're entitled to, however tempting it is, from one point of view, it's not coercion. And the court didn't resolve that at all. I think one reason perhaps that Justices Kagan and Breyer went along is that they realized that the court wasn't doing anything more than it had done in South Dakota v. Dole involving the highway case, when it sort of said, too much pressure, well, that's too much, but we won't tell you how much is too much. It's sort of a sort of Damocles that hangs, and it sort of tells lawmakers they have to worry about how much pressure they're creating, but they're not given any guidance.
Let me add, I think there's one area where that decision may well prove to have practical significance in environmental law. A lot of states are now going to claim that this decision now gives them some leverage to argue that EPA, for instance, under Section 179, is going too far in threatening to deny highway funding. I think that may affect the negotiation between EPA and the states.
Right.
You may find, wholly apart from lawsuits and judicial rulings, the dynamics of how law is actually made is done more informally. And you're going to see the states feel like they're empowered, so they're going to be less likely to give things up. EPA feel a little worried, to be more likely to give things up. To the extent in the past, you had state agencies which could run to the state legislature and say, hey, unless you give us our money, we're going to lose all of our federal highway funds. They could say that before and get the state legislature to say, oh, we can't let that happen. Now, they may say, well, we're not sure we will lose our federal highway funds, and that may cause them to have less leverage and the state legislature be less willing to enact certain laws. So I think it may have a practical effect, wholly apart from whether it actually leads to any formal judicial decisions.
Right. I mean, let me just add, I think Richard's point is really deeply important. I mean, the way law often works is by changing sort of the way the bargaining process looks. It's not necessarily by laying down determinate, predictable lines. It's like the power of a sword of Damocles is not that it falls, but that it hangs. Bargaining occurs under the shadow of the law, and when the law is given a bigger shadow, it changes the bargaining process.
As we wait, I would like to follow up, because one aspect of the Clean Air Act is this federalism notion that the government, and this now in the form of Environmental Protection Agency, sets standards, but they're done by the states in the form of state implementation plans. it is fair to say that those are rather prescriptive. They really are, and particularly under greenhouse gas era, they say precisely what you're supposed to do and even give timing. Is that a coercive act, or is the fact that there is something called the federal implementation plan option, does that really take it out of the coercive world?
In my view, but Richard knows a lot more about the details, so I'll make this very brief, is that the existence of a backup federal plan takes it outside the commandeering world, just as the Supreme Court said in the radiation case of New York versus the United States. That is, if what you're telling states is you better do something, but if you don't, we'll come in and do it, that's not treated as the kind of coercion that triggers the anti-commandeering principle.
No, I think that's absolutely right. And the Clean Air Act is very explicit on this. Clean Air Act says states have to do all these things, all these regulations, and if you don't, then we'll take it over. And actually, in the Sebelius case, the court actually distinguishes the Sebelius case from a situation where the U.S. comes in itself and does its own plan and doesn't force the states to do it. So I think at least there, the federal government is going to be still on very firm ground, and there's less of a threatening sword over it.
Other questions? Please, there in the back.
I had a question about the Sackett case, really for either of you, because I know Professor Tribe, you argued Jackson or General Electric v. Jackson. So you mentioned that the due process issue was dodged by the court in Sackett. I was wondering, though, based on some of the things that Alito said in his concurrence, whether that is the due process issue is considered live, and whether we might actually see the CERCLA due process issue back in the court in the near future.
Well, that's David Block, who wrote one of the papers that I was recommending to you all. I do think that the court has left an open question on the degree to which the Environmental Protection Agency can issue orders with the effect of law, and indeed whether it would make much difference if those orders were written less prescriptively, as Richard suggests. If an order is issued to you, and if defying that order leads to multiplying penalties, isn't that effectively a deprivation of property that ought to be accompanied by a hearing? That question was basically left open. Justice Alito, both in the oral argument in the Sackett case and in the opinion that David is referencing, suggested that it's just un-American to have a government agency empowered to issue an order with the force of law without any kind of hearing. That happens to be my view as well. I'm very much committed to environmental progress, but I think the Constitution sets a framework within which it ought to occur. I represented GE making that argument, ultimately unsuccessfully in the DC Circuit, and cert was denied, then granted in Sackett for various reasons. The Sacketts made a more kind of appealing couple than General Electric. It's not quite as appealing.
Yeah, actually, I think the court, we'll see where the court takes it. The court's had several opportunities to take that issue in the past. They never have. I think people thought there was a good chance they were going to take it in the GE v. Jackson case. It was a major effort done, maybe private bar effort. It's a very compelling cert petition written by Kathleen Sullivan, former member of the Harvard faculty, on behalf of GE. Tremendous amicus support. I think the government breathed a sigh of relief when the court denied cert in that case. And then they were shocked when a few weeks later the court then granted the petition in the Sackett case. I think the fact the court denied one and granted the other actually is more telling. The court could have easily granted both and brought them together. I think they're less interested in the due process issue. The Sackett issue was an issue which they allowed them to avoid the due process and go right to the statutory question. So I think the juxtaposition of denied in one and granted in the other makes me think the court may be less interested in it and less likely to take it. That was a real opportunity to do it. And you can distinguish between the two in that the CERCLA statute, unlike the Clean Water Act, the CERCLA statute actually allows you to defend your noncompliance with administrative order if you had sufficient cause to believe you weren't in violation. So it's less of a strict liability notion. It's not whether you were in violation, it's whether you had sufficient cause to believe you weren't in violation. So there's a little more leeway there. The question is whether that leeway is enough to satisfy the Constitution.
Right. I should say I was co-counsel with Kathleen, my former student and somebody I admire enormously, in the amicus brief in the Sackett case. I think there was a fundamental difference between the two cases in addition to the one that Richard mentions, and that is that in the GE case we had to launch basically a systemic challenge against the whole statutory scheme, whereas in the Sackett case there was an as-applied challenge. And you should know, if you're litigating in the Supreme Court, that as-applied challenges are a lot more attractive to the court than challenges where you take on the way a whole statute is written or administered.
This is for you, Professor Tribe. So when my wife is giving directions somewhere, she never says it's 4 blocks. She'll do it, if you look at the Safeway to the right, it's not there. You go another couple of blocks and you look at the filling station to your left, it's not there. Why did the Supreme Court address the Commerce Clause? Are they giving directions like my wife does?
Well, I haven't met your wife, so I'm not sure. But Chief Justice Roberts was convinced, and in this respect he disagreed dramatically with Justice Ginsburg and those who joined her, that the law couldn't really be plausibly construed as a tax unless it absolutely had to be to avoid some constitutional catastrophe. And so he concluded that unless he decided that Congress had no power to uphold this law under the Commerce Clause, he wasn't going to twist and bend the law to uphold it as a tax. Now, Ginsburg took the view that you don't have to twist or bend the law. It's perfectly natural to see it as a tax. And in that respect, I think Ginsburg was right, Roberts was wrong, and I'm sure your wife is right.
Others, and I'm going to turn to silviculture. Professor Lazarus, why do we have a silviculture rule that would exempt something so obviously harmful to the environment as stormwater? Why does it exist? And secondly, didn't the Department of Justice have to go through sort of legal gymnastics in order to deal with both of those rules and talk about one sort of superseding the other and one applies and the other one doesn't? Isn't there just some, how do those rules apply in this case?
Well, there are 2 rules. There's a 1976 rule and there's a 1990 rule. And basically, the way to see it from a macro perspective is ever since the statute passed in 1972, EPA has sort of bent over backwards to avoid strict regulation of runoff. Part of that is because it's hard to do because of the fact you're trying to deal with something which is coming from stormwater. And there's so many sources potentially subject to regulation of the statute. You actually apply the statute strictly according to its terms. All ditches, all culverts where rain runoff goes, it sweeps up contaminants, all those have to require Section 402 permits. That's a huge administrative job. So EPA has tried since the beginning to avoid doing it because of technical challenges. They decided to avoid doing it because when you start to regulate ditches and culverts, it looks a lot like land use planning. You're starting to tell people how to manage their land and what to do with their land in a proactive sense. That is something which is very politically unpopular for EPA to engage in sort of mandates for land use planning by state and local governments. So they've shied away from it. Congress has actually written in some very explicit exemptions for the agriculture industry because the agriculture industry is very powerful. So things which are clearly point sources are subject to exemptions. The silviculture industry feels a little forlorn that they have not received the same kind of exemptions. Actually, the Farm Bureau filed a brief in the case saying silviculture and agriculture are the same, and the agriculture exemption should be applied to silviculture because it's really farming too. I think this is one of these areas where EPA has had so much on its plate. They've historically shied away from a highly controversial area. Actually, I think that what they're doing is not consistent with the statutory language. I understand practically why they're doing it, but I think they're out of bounds. They were out of bounds in 1976. I think that they're actually departing from the statutory language. A little closer question with the regulation in 1990. But what makes this case still very hard for the environmentalists is they can't challenge the regulations' validity on their face. They have to deal with interpretation of the regulations. And on that one, EPA is going to say, these are our regulations, we're going to tell you what they mean. And that's a very different standard of review. EPA's view has to be plainly erroneous. And that's different than sort of a Chevron test.
It's been widely reported in the news in that case that EPA had another proposed rule, maybe even a final rule that they could actually put out. Why wouldn't they do that? Why would they just, would that moot the case? Would that just turn the case on its ears, or why would they not take action?
Yeah, I don't know why EPA didn't take action. EPA actually told the court, they said, don't take this case because we're about to promulgate a new rule and the whole case isn't going to be important anyway. It was a very compelling reason not to grant it. The law, the applicable law is about to change with our new regulation. The court still granted it. Perhaps at that point, the Solicitor General's office and EPA feels as officers of the court, they shouldn't be mooting the case out right before it's going to be argued. But I'm not quite sure what the internal motivation was.
Other questions? Other questions from the audience? In that case, I want to give both of our panelists an opportunity to sum up, thinking broadly about the Supreme Court, thinking broadly about the term, thinking about the fact that we are in an election year, and those cases like NFIB, which are, you know, essential American politics, but really did, in fact, reach a conclusion which we are all abiding by.
Well, let me just say a very brief word. I think that the court is on the cusp of potentially huge change. For the first time since the mid-1980s, 4 justices are going to be in their mid-70s by the time we have another president, either the same president in his second term or a new president. Justice Ginsburg is going to turn 80 in March. There will be important changes, and there are important things afoot in the Roberts Court, even though I don't think that, as it happens, NFIB against Sebelius portends huge changes for environmental law. I'm in the process of writing a book called Shaking the Foundations: The Roberts Court, the Constitution, and the Future of the Republic. And I don't want to step on my lead by giving away too much about that book, so I'll just leave it there.
I mean, I agree with Professor Tribe. This is a quite significant moment for the court and for environmental law. The court has had a disproportionate interest in environmental law cases for the past many years, and they've been sharply divided on many of them. The justice who has been sort of often the deciding justice is Justice Kennedy.
How
Kennedy,
unusual.
Justice Kennedy has been in the majority in every single environmental case since he joined the court except one. He's always been the bellwether, and he's in that group. He's in that group of four justices who are more senior at this point. So any appointments in that 4 will make a big difference. Make a big difference for environmental law and big difference for the nation.
Ladies and gentlemen, both here at Harvard and all of you that have been with us on the phone lines and by your computers, we're bringing it into this extraordinary panel, this really great look across the horizon of a wonderful institution. Stay tuned. More cases will be granted. More things will be talked about, but yet this is a good look at what we start there in that wonderful time, the first week of October. Please join me now in thanking Professor Tribe and Professor Lazarus.
Thanks a lot.